Good morning, good afternoon, and welcome. I'm Megan Burton with Foley and Lardner. I'm pleased to welcome you to our web conference, Unveiling the Impact of the EU-U.S. Privacy Shield and GDPR. Before I turn our presentation over to our speaker, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit your written questions during the program. Please type your questions on the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximize the PowerPoint presentation on your screen. If you experience technical difficulties during this presentation, please visit the webcast help guide by clicking the help widget below, which designates with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded, and will also be available on Foley's website in the next few days. I will now like to turn the presentation over to Aaron Tanliff.
Well, thank you. So today we're going to talk about, let's move on to the next slide. Today we're going to talk about the EU Safe Harbor, Privacy Shield, and GDPR, and sort of where we are today and what we're looking at tomorrow, or what you should be looking at tomorrow. We're, a brief overview in terms of what we're going to be talking about, in terms of the agenda. First, a little bit on Safe Harbor, as to sort of how we got to where we are with respect to Privacy Shield, and which we'll talk about Privacy Shield. We'll talk about the General Data Protection Regulation, since that has been approved and that will become law, and we're looking at 2018, approximately June, for enforcement. We'll talk about where we are today and what you should be looking at, as well as some guidance for current transborder data flows, as well as some additional commentary on preparing for GDPR. So that's what we're going to look forward to. That's what I'm talking about today. Moving on, so the first thing, sort of, again, we're going to do a quick, just sort of the heads up on sort of the rise and fall of Safe Harbor, and just sort of where we are today. And I think part of it is I'm just entertained by how this all came about. Briefly, there's a bunch of information on the slides. I'm going to, the slides are there obviously for additional substance in terms of what I'm talking about. So I'm going to try not to read anything from the slides, but obviously a lot of what I'm going to say is going to be related to the slides. So the first thing is about 4,400 plus companies had relied upon, or U.S. companies had relied upon, utilizing Safe Harbor to allow them to transfer information cross-border. And what normally, and this was about, that companies had to certify that there were 7 principles that they comply with respect to the EU Data Protection Directive and the Swiss requirements. And if companies were certified, then they registered their certification with those principles, then they would meet sort of that safe harbor scheme, and they could transfer data freely between the EU and the U.S. Now, one of the caveats, these had to be a company that was regulated by the FTC or the Department of Transportation in the U.S., therefore had excluded things like financial institutions, telecommunications, common carriers, ISP providers, labor associations, nonprofit entities, insurance companies, et cetera. Liability was really administration. It was a really sort of administrative order and civil penalties. They went up to about $16,000 a day for violations. In the grand scheme of things, not significant compared to what's coming down the pike. One of the things that, so that's sort of what Safe Harbor was. And then that brings us to sort of one of my favorite stories about all this, sort of how we ended up here today, which was, this, as we all know, Maximilian Schrems, this Australian law student who was studying at Santa Clara University out in California, was taking a class, and in his class on privacy was Facebook's privacy lawyer, who happened to have made a comment. He was talking to the class, and Schrems had some questions all about what was going on in the EU-U.S., et cetera, and asking about privacy. And Schrems made this comment that he was sort of fairly disturbed that this privacy lawyer from Facebook had a very limited grasp of the protection laws in Europe, and it sort of at this point set off the firestorm of what we know today. And it just sort of thinking about had things been different, we wouldn't be in this position today. But it actually is a very interesting story. There's a little bit more detail behind that, but that's really how we ended up here. Obviously, it went first up, and went up to the Irish DPA, who rejected the complaint, and then eventually was appealed to the Court of Ireland, the High Court of Ireland, was referred to the European Court of Justice, and then had determined that the Article 29 while bound by this Article 29 working party decision, that the local DPAs retained independent rights to investigate. And therefore, safe harbor was sort of deemed invalid because the U.S. surveillance program that unfortunately that Snowden had, these revelations that in terms of large-scale collection of personal data. So anyway, so safe harbor gets invalidated. There's a couple of reasons why. The decision was purely looking at safe harbor, which is important because while model contract clauses and binding corporate rules all relate to the same type of thing and have the same sort of limitations, and you want to, as I say, in terms of safe harbor, those weren't actually ruled upon, so those are still valid methods. We'll talk about that certainly a little bit later. Obviously, one of the things that was also brought to light was sort of the variety of the local DPAs in terms of you had your liberal and conservative ones that, like in the UK, noting, don't worry about this, look at model contract clauses. We're not going to enforce, we're going to sort of take a wait and see approach as we come up with new guidelines, all the way sort of to the end of it, to the more conservative side, really coming out of Germany, believing that sort of things like the model contract clauses and binding corporate rules sort of do fail for the same problem that safe harbor does, and believes they may not provide protection. So, and they're refusing new sort of proposals based upon that. So then that gets us really into Privacy Shield, where we are today. And the important thing about Privacy Shield is that, again, Privacy Shield is this new, like Safe Harbor, self-certification process. They have requirements set out to be done. It's going to be monitored by the Department of Commerce, who will actually have to verify companies and their compliance, that the privacy policy is presented in line with sort of the Privacy Shield principles and are available. That the U.S. has committed to maintaining an updated list of current Privacy Shield members, as well as removing those that have left the arrangement. One of the important things about Privacy Shield versus Safe Harbor, there was a study done and lots of commentary that a majority of companies, and depending on which one you read, some companies, majority of companies, et cetera, who were under Safe Harbor really weren't compliant or properly compliant. And so one of the things that Privacy Shield is supposed to have is a much more regimented process for ensuring that sort of compliance. One of the things that I've talked about before is when you talk about joining Privacy Shield, beware sort of the tail end that some companies may decide to leave, but as long as you still have that information that you've collected that would be pursuant to a Privacy Shield and you're still utilizing that information, you're still bound by all the same obligations that Privacy Shield had, whether you're registered or not. So that's one of the questions companies need to ask themselves. Certainly there's a lot to talk about whether Privacy Shield is right for you. So as long as one of the important things about about Privacy Shield is that there really is this data flow is really essential to the sort of the EU-U.S. trade relationship. That's an important part of the relationship. That cross-border data flow between the EU and the U.S. is is sort of twice that between that of the EU and the U.S. and Asia. It is one of the most significant flows of data that exists. More than 50% of U.S. companies have relied upon, more than 50% of the companies that have relied upon Safe Harbor to transfer data are transferring actually also personnel files over terms of workers or employees that are overseas. Back into the U.S. for human resources purposes, and so it became a critical part of business operations, and it's sort of if you look at they believe it's more than a $600 billion industry that relies upon the transfer of information from the EU to the U.S. They believe obviously significant negative impact on EU GDP as well as U.S. numbers. If Safe Harbor, or sorry, if Privacy Shield were not to be approved or not to be able to utilize, a drop in the U.S. economy as well. There's lots of fallout potentially if Privacy Shield does not work in terms of banks in the U.S. being unable to lend money to those in Europe, insurance companies not able to write policies to EU citizens or EU markets or your companies because of relying upon documents of policyholders. Writing software code, things like in open source and other places, because repositories, a lot of them are in the U.S. There's a lot of online education, long-distance learning. There's a lot of online services that wouldn't be able to operate. I've done a lot of work with travel companies that operate on a global basis, and that wouldn't be able to happen in terms of transferring certain information, as well as all sort of lots of other data flows and storage of information. So one of the things in terms of Privacy Shield, there's a few other things in terms, so what does it offer? One of the things it's supposed to offer is strong obligations on companies handling of EU citizen data. In terms of U.S. companies, we're supposed to be able to import personal data from Europe. We'll be required to commit to sort of new robust obligations on how they process personal data, as well as sort of onward transfers. And the Department of Commerce, as I mentioned, will regularly review companies that are self-certifying to Privacy Shield to ensure that they publish their commitments. So again, it's supposed to address the problems in the past where companies would sort of self-certify and may or may not be compliant. The FTC will be enforcing them, and non-compliant companies will face sanctions and potential removal from the list. There's also additional safeguards and transparency obligations in terms of the U.S. government agency access, which is one of the issues. In terms of the Office of the National Intelligence Service, sort of written assurances to the U.S. government will not conduct these indiscriminate mass surveillance on EU citizens' personal data. Public authorities, and access to EU data for law enforcement and national security purposes will be subject to certain limitations. That'll be transparent. There'll be safeguards in place with oversight mechanisms to make sure they're not abused. There's going to be certain types of exemptions in terms of things that are necessary and proportionate. There'll also be between the EU Commission and the U.S. Commerce Department on annual review of the agreement beginning in 2017, consultation with the National Intelligence Services and as well as the local data protection authorities within the EU to ensure that any authority that the agreement can be suspended if there's any problems with respect to that. They're also talking about creating, this special ombudsman to be housed within the U.S. State Department who will be empowered to respond to DPA complaints regarding national security access to data. And then on this slide, as you see as well, there's some additional Privacy Shield redress mechanisms what are going to be provided for free to better enable EU citizens who believe that they've been harmed or they have questions or concerns about the use of their personal data to have access to sort of easier, better, free mechanisms to address that. One of them is, and there's a slight disconnect here, you have the companies need to respond within 45 days. There's also some other mechanisms both under GDPR and other issues in terms of responding within 30 days. So there's going to be some things I think that will have to get worked out. But also there's also an alternate dispute resolution mechanism that will be provided at no cost to citizens, a little bit different from what was under Safe Harbor. There's also the Data Protection Authority has citizens have the ability to complain or comment to the DPAs, and that will get referred directly to the Department of Commerce, the FTC, who will be required to investigate and swiftly resolve these issues, as well as this idea of the referral to the ombudsman, for security purposes, and this whole idea of under this Privacy Shield panel, there'll be this arbitration mechanism to ensure enforcement as well. Oops. Switch slides here. Okay. So we all know it's nothing new now in terms of Article 29 said, well, this was great. We made a lot of improvements on Privacy Shield over Safe Harbor, but still hasn't addressed all the concerns that we have under, with respect to Privacy Shield. We're not yet endorsing it. We think there's a lot that can be there. We think there's a couple of things that can be done. Certainly the things that were of most concern under Safe Harbor, why it was invalidated, they feel just not there. In terms of this issue of surveillance, they felt that just wasn't limited enough. They felt as well as the documents weren't clean enough, weren't clear enough. This ombudsman really wasn't independent enough, and the availability of effective remedies. And so there was a couple of things that they suggested that we can make improvements on. And as you all know, that went back. Sorry, I'm on the next slide here. And that went back, and they said, it was a little complex, and it just wasn't. They just didn't hit the. They just didn't really hit the target they were looking for, and they suggested that additional work be done. And as we all know, that there's that's sort of the question. That the first thing is that we all know Article 29 Working Party's opinion, while instructive, is not authoritative and is only advisory, and therefore Privacy Shield could move forward despite Article 29 Working Party's comments. At this point, and then suggested the EU and the U.S. go back to the table and work on those things. We've all seen commentary that may not be of the at interest right now between with the EU and the U.S. Many feel that it's it's sufficient for what the purpose is. Certainly, U.S. organizations and even a lot of EU organizations and the governments are interested in this all moving forward because certainly of the concern that this does impact global business both in the U.S. and the EU. There's still Article 31, who's going to make some commentary on this. Many of us feel that they're pretty much going to be in favor of Privacy Shield. Those recommendations will go to the EU Commission, and one of the concerns, one of the thoughts right now is that we will see that Privacy Shield move forward, probably around June, sometime like that. Unclear, but one of the concerns there is certainly if it does move forward in its present state, and the issues that brought up by Article 29 Working Party have not been addressed, I can certainly see this thing right back in court, and the complaint being pre-drafted based upon the statements by Article 29 Working Party. So. We'll see what happens with that, but with respect, the issue is a lot. There's it's not yet approved. There are some things within Privacy Shield that are worth talking about, which we'll talk about at the end of the presentation in terms of moving forward and where we are today. But so we'll flip over and talk about GDPR and in terms of what that is, because as we all know, that has sort of been approved. It's going to be published in the EU official journal, and it's going to it'll be effective 20 days following publication, 2-year implementation period, and then so again around June 2018 enforcement will start. The important thing about this is we all know GDPR really looks at the processing of personal data and tries to hold people more accountable. It provides individuals with stronger rights. There's enhanced enforcement measures for the data protection authorities. But what some of the interesting things that it applies obviously to organizations that are outside the EU, nothing to do with the EU. I shouldn't say nothing to do with the EU, but organizations that are not present in the EU, and we'll talk about that a little bit more, but that provides goods and services to the EU. So it really brings in a whole number of other, a whole set of other companies that wouldn't otherwise be subject to European data protection laws. Obviously, GDPR is separate from Privacy Shield. I don't want to say one has nothing to do with the other, but the rejection of Privacy Shield really doesn't impact GDPR. And obviously, GDPR is to replace the EU Data Protection Directive in '95. It's also going to replace one of the things, the DPA as well, which we'll talk about sort of the conversion of the DPA to the Supervisory Authority in just a second. But in terms of covered data that we're going to see underneath GDPR, it's really any information which a living individual is identified or identifiable by anyone. The current test, all means reasonably likely to be used to identify, is still retained under GDPR. But one of the things that GDPR sort of highlights is that certain categories of online data may be personal. There's additional online identifiers, device identifiers, cookies, IDs, IP addresses are all sort of referred to within GDPR. And certainly provides a clarification under some of the other laws that are out there in some cases as well. The concept, there's also a concept of sensitive personal data is retained, and it covers genetic data and biometric data. And there's also, under the current directive, processing of sensitive personal data subject to more stringent sort of conditions than other forms of personal data. and sensitive personal data can be processed with explicit consent, which again, we'll talk about all this in just a second. So we'll start off with the supervisory authority. Essentially, the supervisory authority were essentially the DPAs. As I just mentioned, since DPA is going to be replaced because that was related to the directive. So we're going to now have these supervisory authorities, which will sort of supervise, if you want to call it, the data protection laws on a region. So there are specific national laws, but there's going to be a lead supervisory authority located within each EU member state, which will be sort of where an organization is going to have sort of its main, what's going to be sort of headquartered is one, or it's going to be, or if it's a single establishment within the EU. But the whole idea here is that the authority, the supervisory authority, will cooperate with other authorities. And they will sort of create the European Data Protection Board, which we'll talk about as well in a moment. And they'll issue opinions on particular decisions. But the whole idea here is that there's going to be this supervisory authority in each jurisdiction, and usually where a company is located or where they're processing the information, that's where the decisions will be made. They'll be sort of made localized. Now, one of the problems is that you may have companies who are localized or headquartered in a particular place, but have main sort of, let's say, processing in a couple of locations, and that could lead to some potential forum shopping. It's not supposed to, but one of the issues is it was supposed to create a single location for addressing privacy and data protection issues for a company, because you have the local supervisory authority addressing the company in its local jurisdiction. But as I said, that doesn't always work, and potentially there could be some potential forum shopping on that. But one of the issues here, because you do have these local supervisory authorities, I believe establishing relationships with them, working with them, will certainly be key to a successful implementation. One of the things, again, with the supervisory authorities, sorry, is that they are, so I just mentioned in terms of companies that may be located in multiple jurisdictions, the GDPR does allow for them to have certainly a central point of enforcement through this sort of, what you want to call this one-stop shop mechanism, and it really is supposed to be based upon, again, that main establishment. And they're going to, as I said, they're going to interact with each, the supervisory authorities will interact with each other. They will have a say when certainly you're talking about cross-border interaction, data flowing outside. But each of the supervisory authorities will have sort of independent and be competent to handle sort of local complaints or deal purely with local infringements of the GDPR. So again, you don't have to, you can keep it all local, and theoretically it should make it a little bit easier to address particular issues. Next thing is sort of, as I just mentioned, sort of the idea of the European Data Protection Board. The whole idea here is sort of to encourage, the harmonization of applications and enforcement across all of the EU. This will be sort of the joint operations of all the supervisory authorities from each of the different member states, and they'll be encouraged where appropriate, and they'll be able to seek sort of, so a supervisory authority can then, if it's appropriate, to go to the European Data Protection Board, which again is made up of all the SAs and across the jurisdictions, and if, in order to sort of establish a consistent application of GDPR. The whole idea is that we're trying, not we, but they're trying to keep it consistent regardless of where you are, a little bit different, obviously, than current process, and trying to avoid things like forum shopping and otherwise. So it's trying to combat that particular issue. But again, the whole point of the board here is to do things like issue guidelines, recommendations, and opining on a local supervisory authority's application of the GDPR, again, to sort of ensure that it sort of stays consistent. And it will advise the Commission, just like now Article 29 Working Party provides advice to the Commission. This European Data Protection Board will also sort of advise the Commission, but will be a separate entity, a separate legal entity from the Commission, from the Board, and will have sort of its own power to adopt binding decisions and disputes between member state supervisory authorities. So In terms of jurisdictional issues, as I just mentioned sort of a little bit in the overview of GDPR, GDPR is really going to apply whenever there's personal data being processed about an EU resident in connection with the offer of any goods or services or the monitoring of behavior within the EU. So this could be the case, again, even for an organization that has no presence in the EU. So organizations that would have not been subject to European data protection laws prior to GDPR will now find themselves having to consider and potentially be subject to GDPR. The idea, there's a lot of potential factors. You're looking at what's the language on the website, what currency are they selling or making things available in? Can people in the EU place orders? Can things be shipped to the EU? Are there services being provided to EU residents? What are the references to the EU? Who are the customers? The ability to track EU residents on the internet, and the ability to create profiles, analyze behavior, etc. All that's covered sort of by this. So the whole idea here is that GDPR has this sort of long arm, can reach out and really impact, and really sort of cover entities that are not located in there. So again, as I said, there's a lot of international non-EU businesses that would become subject to the EU data protection regulations, sort of underneath this, underneath GDPR. Now, one of the other elements of GDPR is sort of this idea of privacy by design. So the idea of individuals in terms of the processing, there's going to also be this, throughout this idea of GDPR, this idea of transparency. There's they have to make certain obligations that are going to apply across the EU, sort of making things sort of very clear. How organizations are going to comply. Organizations are going to have to be able to provide a concise, transparent, intelligible sort of disclosure of what they're doing. The whole idea is that GDPR, that the controls that companies will have to enact will have to enable will have to enable companies and enable individuals as well to understand in terms of what they're doing privacy-wise. Transparency is a term, as I mentioned here, has been, is in GDPR mentioned a number of times. And the bottom line is that what a company is doing is, needs to be made clear and transparent with individuals. That means things like, and we'll talk about it, it means sort of like, for example, disclosing sort of a privacy notice. So, under GDPR, data controllers and processors, et cetera, they must make, must provide a privacy policy or other privacy or notice or disclosure on the website or otherwise available, depending on, again, the nature of the business, but discloses, how they process with personal information. And again, and one of the things that GDPR sort of does introduce is this idea of standardized icons as a way to inform individuals of what they're going to be doing and how they're going to be processing information. I think that's, it's certainly an interesting twist in terms of what's going on now. Certainly companies talk about disclosing of how they process information, but this takes it to a new level. It also does potentially impact a number of organizations that have different disclosure obligations under different regulations, whether it's SEC or otherwise, in terms of how they make things available. One of the things in terms of the companies will have to address, there are some. I note here as well that there are some exemptions in terms of all this, that there are going to be certain small and medium-sized enterprises that have less than 250 employees that also not processing certain sensitive information that won't have to comply necessarily with certain of these privacy by design mechanisms in terms of submitting routine notifications to a DPA or the SA in terms of processing, in terms of keeping these detailed records of personal data processing. This certainly being a slightly onerous process in terms of how information is processed and stored. So there is an exemption for some of these entities, but those companies that do engage in certain we'll talk about in just another slide, certain high-risk processing, that exemption does not exist for them. But bottom line is that companies, controllers and processors do need to keep internal records, the processing, what they carry out, including the names and contact information, details for processor controllers and joint controllers, and to be able to provide those, again, to the SA as well. I'm here talking in terms of privacy risk assessments. The idea here is that processors and controllers alike will have to maintain, again, as I said, maintain the processing records, but they're going to have to carry out a privacy impact assessment, which is going to address or demonstrate in terms of, with respect to high-risk data subjects, the ability to, to process this information, and they'll have to consider certain activities that relate to high risk, and what they're going to be doing to ensure the protection of that information before they can process personal data. That also will have to be shared with the SA upon request. There's also, in terms of some of the other things in terms of this risk-based approach, some of the there's also sort of accountability obligations. Companies will have to implement appropriate privacy policies and robust security measures and perform these data protection impact assessments, as I just mentioned, under certain circumstances. Both, as I said, both data controllers and processors will have to maintain those records. It's not enough for organizations to just be responsible for compliance. They must demonstrate compliance with respect to data protection principles and, where appropriate, through the adoption of policies. They'll have to adhere to certain approved codes of conduct as a way of demonstrating compliance. And then anytime these new, and certainly talking about the risk-based approach, where there's a high risk for privacy of individuals because it's new technology, new processes, whether it's monitoring activities, the controller must undertake and document, again, that impact assessment, must evaluate the risks, how they can limit them. As the compliance will be established with codes of conduct, and then the conclusion, or then the assessments must be shared, again, with the relevant data protection authorities and obtain their view on whether or not they've met their obligations to protect that information. Then we have sort of data protection authorities, the data protection officers. Sorry about that. So each controller processor, which is a public body or involved in certain sensitive activity, must appoint a data protection officer. It's not required for everyone. It's certainly required for, as you see here, organizations that regularly and systematically gather information as part of its core activities. Certainly companies that process large amounts of sensitive data, but these are supposed to be independent bodies that are sort of to sort of oversee the data protection obligations of a company. Now, these can be an employee of a company, doesn't have to be. They must be independent of the operations, though. These can be outsourced. I do see potentially the idea of a cottage industry of DPOs, just like things like registered agents, where you have a mailbox somewhere and someone's a registered agent for who knows how many companies. There could be this with a DPO. It certainly depends, certainly, on the nature of the company itself. But the whole idea, as well as you can be a DPO for multiple subsidiaries as long as it's easily accessible from each establishment for the DPO. And in terms of the DPO, has a number of responsibilities. It's supposed to inform and advise the controllers and processors of obligations under GDPR, as well as the data protection laws. It's supposed to monitor the activities of the company. They're responsible for training internal staff and performing audits. They're supposed to provide advice with respect to those privacy impact assessments. They're the ones supposed to liaise with the supervisory authorities. And they're also really the point of contact for inquiries, which is, for data subjects, withdrawal, and a number of other things as well. But they're supposed to. Now, one of the things that's important, let me just mention before I start talking about the next topic with DPOs. Again, even companies that are outside the EU will need to appoint, that do fall under GDPR and do process information that will become subject to GDPR and subject to a DPO. Will have to obviously have a DPO as well. Has nothing to do with jurisdiction. Another thing that, so on the next slide here on pseudonymization, another thing that GDPR does, they have this concept called pseudonymization. They have this sort of affirmative obligation or affirmative obligation for companies to investigate, and it's this additional privacy mechanism separate from encryption, where information you can sort of transfer information related to a particular individual separately from other information from a company. It's the idea of its personal information. GDPR sort of does encourage its use, but it sort of separates out the idea of the identifiable information of an individual with the rest of the information. It creates sort of two data sets, potentially. There's different ways of implementing this, but the whole idea is one is sort of the key. You may have potentially the identifiable information in one with a key, with a number or whatever else it may be, and another database that may have all the other sensitive information, but that wouldn't be connected to an individual. And then there's these two databases are kept separate, transferred separately. There's a way to connect the two of them and be able to sort of to evaluate that information. And then you would certainly use certain measures to sort of re-identify that information in there. It's one of the pseudonymization and encryption are things that GDPR actively tells companies to investigate and to utilize. Consent. Consent is a big issue underneath GDPR. It must be ambiguous. Consent is necessary to process sensitive personal data, and it must be explicit. However, consent to process other types of personal data that are not deemed sensitive does not necessarily need to be explicit. Consent must be specific, informed, and active. Consent can be indicated by choosing certain technical settings or some other statement or conduct which would indicate acceptance. However, the idea of silence or inactivity is not sufficient. The idea of having a box, for example, that's pre-checked, or by saying, by remaining silent, by not, the whole idea of, let's say, opting out, or the whole, makes it sort of very clear that there must be something that an individual does to indicate their consent to the processing of their sensitive information. Consent must be freely given. Individuals must be able to withdraw it without any type of negative impact on their ability to utilize services or any other impact to them. It should not be tied, and when an individual is going to enter into a contract, the idea of consenting to the processing of sensitive information should not be tied to the user giving consent, to that contract. They should be separate. Organizations, there's sort of a presumption that if there's sort of a forced sort of acceptance or consent, that those mechanisms are not valid. So there's a lot of potential mechanisms that are currently in place that I believe underneath GDPR will have to be redesigned so as to present sort of a more granular, genuine, affirmative consent by individuals for the processing of that information. Now, there's certainly processing for other types of information. There's other types of information that don't require, or other types of processing that don't get subject to this, such as the legal processing, legitimate interests of the controller. There's certain interests that don't get, that as long as they don't get overridden by the data protection rights of the individual, consent isn't necessary for some of those things as well. For example, processing in order to prevent fraud. Direct marketing and network security are all cited as examples of processing being carried out for legitimate interest. And sharing data, certainly within a group for certain undertakings may be also legitimate interest as well. One of the interesting things that was noted, public bodies are not able to rely upon this as legitimate interest for justification, so consent would be needed as well. One of the interesting things that I believe creates sort of a divide amongst the, that could create a divide amongst the different jurisdictions, which would really require this instead of a sort of a generic EU sort of application of GDPR, is this issue of consent of age, for example. Right now, under GDPR, children under 13 can never give consent on their own for the processing of information. You'll need parental or guardian consent. Children over 16 years old can always give consent themselves. However, between the ages of 13 and 16, it's actually up to each member state. So you could see you could see different member states deciding it's age 13, 14, 15, 16, whatever it may be, and you'll have to sort of be aware that different member states could have different ages of consent. There are and also there's no specific rules relating to parental consent for offline data processing. Usually member state rules have their own sort of process for doing so. With respect to outsourcing to data processors, one of the things that GDPR also does clarify that it does relate to the processing of personal data by both EU and non-EU controllers and processors. Again, if you go, prior to GDPR, really processors were sort of in a separate or separate entity, or held sort of separately. They were, it was the controller who was really responsible. The controller contractually obligated with the processor, but underneath GDPR, there's actually direct connection between obligation to the controllers and the processors. So there's also as I said, this also does increase the coverage to non-EU businesses, because there's a number of non-EU businesses that also process information outside of outside of the EU as well. And the allocation of responsibility, we're going to talk, in terms of contractual obligations between companies, are also going to be relatively important. I just want to make sure we cover everything in terms of timing here, so I'll try and sum up a little bit more here. But the whole idea here now is that the current system, again, controllers were responsible for the access, and now both controllers and processors are going to be covered. It does stipulate, GDPR does stipulate that if processors do want to have a sub-processor as well, now they must get consent for that to transfer, to appoint a sub-processor in any type of transfer of personnel out of the EU as well. The GDPR also provides the right that says a controller can always audit a processor. There's going to be, one of the concerns or one of the things I foresee is sort of standard contracts, and we'll see throughout. There's a couple other things that are worth bringing up in terms of what processors are going to have. And so if you look at a lot of the controller processor contracts that currently exist, there's a lot of things that processors, I don't want to say to get away with, but don't have to agree with. And you see a lot of contracts that processors don't have as many obligations, or it's not consistent across, I should say, contracts in terms of their obligations. So there's going to be a difference in contracting styles going forward, just because there's going to be this issue of there's going to be a lot of requirements now directly from GDPR onto the processors, so things they can't contractually get out of. So in terms of new rights for data subjects, obviously there's a lot of focus on that as well. First of all, there's the right of access and rectification. There's also the right to be forgotten. They'll have to make certain personal information and provide steps in order to ensure the erasure of personal information. Although that right is not absolute, they still may process certain types of personal data, notwithstanding an objection from the individual, because there may be a compelling legitimate ground for continued processing. And individuals are also given the right to object to certain certain types of processing of information. Again, not all rights are absolute. Certainly, there are mechanisms that the controller actually has interest that would outweigh those of an individual. It's important to note that one of the comments about all GDPR in general has been that an individual's right to privacy is not an absolute right. There are other compelling interests as well. One of them. Okay, and then some additional rights is data portability. Gives this new idea that individuals can take their data from one service provider to another. They have this right to port the data, provided it's obviously technically feasible. However, it's a little unclear how one provider would still talk to the other, how they would transfer that information, so that's something still needs to be worked out. Some additional rights on automated decision marketing. One of the things is this ability of controllers who can engage in this entirely automated process would be restricted if it can produce potential legal effects or could significantly affect an individual. The individual, again, has the right to object to certain processing. Appropriate protections would need to be put into place. There's also, again, certain individuals wouldn't have the right to object to certain individuals, into certain processing. But the whole idea is that GDPR is supposed to strengthen the protection of individuals against sort of the negative effects of profiling them via these automated processes, these automated decision-making processes. And so anything that could profile or have a negative impact on the individual is going to be is addressed, and individuals have rights to prevent that processing as well. Security requirements, GDPR certainly has its share of those as well. As I already mentioned, pseudonymization, certainly encryption being another one. And again, as I mentioned, there's this obligation for companies, controllers or processors alike to consider pseudonymization and encryption to ensure ongoing confidentiality, integrity, availability of information. as well as to make sure their systems are resilient, their ability to have proper backup, and disaster recovery, the ability to restore access to information. They're supposed to test the systems on a regular basis, assess and evaluate the effectiveness of security measures, and to make sure that they are tested and valid and that they're anything that's remediated. Sorry, just mentioned that as well. Skipping on, data breach notifications is as well. One of the things that, in terms of a breach of, or a personal data breach is defined, under GDPR is defined as sort of this breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. It's a fairly broad definition of a breach. We'll talk about that now as we go to the next slide. So in terms of these obligations under breach notification, there's a couple of different sort of obligations. So for controllers must notify the supervisory authority without undue delay within 72 hours, assuming it's, and where feasible, no later than 72 hours after becoming aware of the breach. Notification can be phased if necessary. There's no obligation to report a breach where it's unlikely to result in a risk to the individuals. However, organizations must retain records of the breaches, and so supervisory authorities are able to address compliance as applicable. Where there is notification, it must contain details of the nature of the breach and its scale, such as the types of data, volume, number of individuals, the types of records affected, as well as the likely consequences and mitigating steps should be provided as well in terms of what could happen based on the information of what's being done. That's notification to the supervisory authorities. To individuals, again, notification is only required where there's a high risk posed to them, which creates this interesting sort of dilemma as to what that means, but notice needs to be provided without delay in clear language, and it should include information about mitigating steps and contain a point of contact for more information. There is no obligation to notify breaches if the risk has been mitigated. So, for example, if the information is encrypted, or even after the breach, if there's an action taken by the controller that would mitigate the impact and would prevent harm or to an individual, no notification is given. However, that again separate from notification to the supervisory authorities. And notice can also be given via some type of public announcement in certain circumstances. Processors have a different sort of obligation under breach notification. They provide notification to the controllers, but not to the supervisory authorities and not to individuals. So there's a whole bunch of again, something that processors really didn't have to worry about before, but something they need to ensure that they have the processes in place to ensure that they can provide that notification to the controllers. Again, I mentioned this already in terms of the individuals, so we can move on. Financial penalties. This is yet another another interesting thing about GDPR. It sort of changes. I mentioned at the very beginning, Safe Harbor had some financial penalties, but they really weren't significant for most people felt. GDPR, a lot different. Under this new regime, we talk about up to 20 million euros or 4% of the annual turnover, the global turnover of a company, whichever is greater. There's sort of two levels of harm, administrative harm at 10 million euros or 2%, and sort of a breach of personal information or GDPR up to 20 million or 4%. So again, infringements, there's administrative fines, et cetera. Currently, interestingly enough, the power to impose fines is only up to 500,000 pounds for serious breach. So obviously, this has a much greater exposure to both EU companies and the U.S. companies, as well as any company globally that actually does business, that would fall under GDPR. Individuals as well are entitled to claim compensation for this material or immaterial damage from the controller or the processor. However, processors are only liable for those breaches that would be subject to GDPR under the provisions of GDPR, which are directed to processors. So they're not, they don't have the full liability that a controller would have. The burden of proof is on the organization to show that they are not responsible for the event which caused damage. So there's just an affirmative obligation on them. In terms of transfers of data outside of the EU, the current system has some is fairly broad. There's a number of existing measures for transferring personal data other than safe harbor. A lot of those do continue to be recognized under GDPR. I mentioned in the beginning standard contractual clauses, certainly as well as binding corporate rules. These things remain valid because they were not necessarily ruled in the decision by the European Court of Justice when it ruled safe harbor invalid. However, one interesting thing, GDPR does write into law in terms of requirements for binding corporate rules. So that's something to think about, something important we'll talk about in just a second. Understand that under the process where there's transfers based upon the standard contractual clauses, you have to notify or be approved by the Data Protection Authority. That whole process is abolished. This idea of that before you can do so, you have to provide notice. There are some other transfers that are available as well. There's also the right, in terms of consent. But one of these things is that GDPR also makes it clear that it is not lawful to transfer personal data out of the EU in response to a legal requirement from a third country. And so there's some other obligations in there in terms of how to address that. So running into the end, sort of get to the end of this presentation, I want to talk about sort of some guidance for transfers of information. So one of the important things I want to talk about, or let me first bring up, is that a lot of companies are under this impression that nothing is going to happen to them right now until everything is sort of said and done. Not true. An example, the Hamburg-based in Germany, the Hamburg Data Protection Authorities have brought action, have investigated against several companies, and they're currently investigating these Hamburg-based subsidiaries of U.S. companies for unauthorized transfers of data to the U.S. In some cases, the companies were unable to provide a mechanism in which they were providing it. In other cases, they failed to properly certify that they were. And these are actually all companies, I should say, that were certified to transfer information under safe harbor, but they're currently not transferring data underneath any recognizable mechanism. And so that there, as I said, in Germany they are, and I mentioned Germany is one of the more conservative locations, but they are addressing, or they are investigating and potentially levying fines against some of these companies that are over there. So again, transfers via safe harbor not valid. Transfers via Privacy Shield, very interesting. Obviously doesn't exist, but there is a company out there that is offering to certify you for Privacy Shield. They have a logo. You can pay money. They claim they will certify you. Cannot happen, does not happen. Privacy Shield is not a valid mechanism yet. So please don't transfer information, or do not say that you're certified under Privacy Shield. I've actually seen a company make that statement as well. Does not exist. Article 29 Working Party and the various DPAs have asserted that while they are in this wait-and-see approach, they will bring action on a case-by-case basis. We have seen this, as I just mentioned, in Germany as well. There's some other things pending as well. There are certain valid transfers that are currently the standard contractual clauses and binding corporate rules. Obviously, these will be looked at in terms of the adequacy of these mechanisms. Article 29 Working Party has addressed that. There's a difference between binding corporate rules, standard contractual clauses as well. Binding corporate rules, because of GDPR and because of certain, other, in terms of getting outside of Privacy Shield and issues under GDPR, are actually becoming a little bit more favorable. I have clients who are talking about looking at that a little bit more. I think there's about 80 companies now who have BCRs in place, and the list of companies and looking at that is growing. But binding corporate rules are generally within an organizational structure. It's how a company transfers information cross-border throughout its entities. Generally takes about 18 months to approve. I'm hearing could be up to 30 months right now in the current environment. They're very difficult to draft and get into place, but they are. That is something that companies are looking at. Standard contractual clauses, relatively quickly and easy to execute. They don't require regulatory approval if you don't change them. They're called standard for a reason. I've seen lots of companies try and modify these things. A lot of controllers try and modify them, and it's rather disturbing because then it actually doesn't. You actually do require then approval from a DPA in order in each of the member states to say that that's valid for that jurisdiction. One of the interesting things, they're EU controller to EU or non-EU processor, or for EU processor to EU non-processor, but there is no non-EU controller to EU processor. It doesn't make sense. I have seen some entertaining documents that look like that. Because the issue is about exporting information from the EU into the U.S. Obviously, and you require a standard SCC for each per export, so they can be a little bit onerous, to say the least. But again, standard contractual clauses, the highlight of those, they can't be modified again without DPA review. I just mentioned there's Appendix 1 and 2, and there's a few things that you can make some other changes to, through a data use agreement that don't contradict it. You'll fill in some information. There's some optional language like an indemnification limitation of liability that could be put in there, which is separate. But again, I've seen lots of vendors try and modify these things. So some other additional recommendations for cross-border. There's a number of organizations, again, SECs, we're currently seeing a lot of those in place. Consent is another issue, which I mentioned as well. Consent under GDPR, whether it's under current mechanism or GDPR, again, as I mentioned earlier, must be freely specifically given. It's really difficult, actually, interesting to sort of comply with consent, but there are, for certain organizations, we've worked with them to develop, a consent mechanisms that would work under this, but again, it's all case specific. In their organization, that was, based upon what they were doing, that was relevant. Consent is very difficult, as for those in terms of you can't really get consent from an employee. Certainly, a lot of the DPAs, and Germany's got a really nice statement on this, that you can't really get an employee to freely consent to the transfer of their information because the potential impact on their employment. So in terms of preparing for GDPR, a couple last things, just things to think about. As I said, GDPR enforcement will begin around June 2018. There's a significant number of things to get into place for companies. One of the things that's important is that it does shift the issue of privacy and personal data protection even further from within the IT organization at a company up to the board of directors C-suite. There are obligations underneath that to make the senior officials in a company aware of their obligations, the company's obligations. One of the issues of the DPO is to ensure that they're made aware of these obligations. There's also going to be some, but the companies who are subject to regulation on the U.S. side of the house will certainly need potentially to think about disclosing those potential increased operational costs and potential higher liabilities. It's a little interesting if you think about that the liability under GDPR can be significant, the obligations can be significant, and so potentially, depending on the organization, that may be something to consider. One of the other things, another thing worth starting in terms of where you start today, preparing a data inventory, understanding what you're doing now with your information, starting to put into place to do privacy impact assessments if they're needed. You need to review your information security policies to make sure they comply, both from a technical, administrative, and physical measure. You need to make sure that you protect the confidentiality, integrity, and availability of information. You start to really maintain those detailed records of personal data processing. I've seen those. A lot of companies that I've seen and talked with, I don't know if those necessarily, in terms of ones that I've seen, I don't believe comply currently with what GDPR is asking for. The idea of privacy by design we talked about. The ability to, obviously review privacy policies. That's going to be important under Privacy Shield, under GDPR, to make sure those are clear and plain and they fully disclose all the data collection practices and how that information is being processed. Methods that companies obtain consent for the processing and collection of information need to be reviewed, make sure they're unambiguous, make sure they have opt-in consent, they're specific. Start thinking about a DPO if that's going to be applicable. Dealing with the supervisory authorities, obviously at some point you're going to want to build that relationship with them. And another important thing is based upon, again, this increased liability scope and obligations is to really review your insurance obligations for scope and coverage. And I don't think I have it here on a bullet point, but one of the other things, so I think, and that's we'll run into that in one second. But one of the things to be aware of with respect to all of this is you're really going to need to review all of your contracts with all third parties, whether it's controllers and processors, whether it's third parties and vendors and service providers that you provide information to ensure that they maintain that. One of the things that's critical, that's always been critical, but really now becomes critical, is to make sure that they maintain and protect the information, the personal data, the same level and obligation that you are, assuming obviously that you're complying with the laws as well, but to make sure that everyone that is compliant. It's going to be important to make sure and to document that process that they have that controlled. So my contact information is here. I'm going to ask if there's any questions. If there's any Q&A, if anyone has any questions. I do see there are some questions in the queue, and I think I have just a moment. I think we're at the end of time. So one question is consent still recommended as it can be withdrawn at any time? What fallback options do you recommend for businesses that collect personal data from a multitude of individuals? One of the things that, obviously consent is going to be, depending on which type of consent we're talking about, but I think the issue here is that you're always going to need consent to collect information from individuals, to process that information, collect, store, process, transfer, disclose, et cetera. Individuals do have the ability to withdraw that consent, which does put problems in place, but it's not an absolute right. There are certain, and I mentioned in the deck, and I can certainly follow up, but there are certain rights that you can still continue to process certain types of information, even absent the consent, but there's a limitation of what you'll be able to do with it. I do believe that consent will always be there, will always be critical. It's something that, then again, that it's this absolute right that an individual does have under GDPR, as the GDPR does empower individuals with additional rights and obligations, and that's one of them. But there are, as I said, there are some exceptions to that in terms of how you can still process information after consent has been withdrawn. But I think I'll leave it at that because I think we're out of time. All the other questions, feel free to contact me. I'll follow up any questions with anyone else individually because I believe we're now out of time.
Thank you, Aaron. We invite you to contact Aaron if you have any additional questions. Just a reminder that this web conference is being recorded and available on Foley's website in the next few days. Thank you for your participation.